Hello everyone. So in continuance of our last lecture on jurisdiction, today we will discuss section 9 of Code of Civil Procedure. So last discussion was on jurisdiction in general. Today we will talk word to word what is there in section 9 in CPC. So CPC section 9 talks about jurisdiction and what kind of suits or what kind of civil cases can a court address. So to start the lecture, I would like to just read a plain reading of the Bare Act provision, that is section 9. And this is my recommendation. If you are reading any of the law subject and if that subject has Bare Act, okay, because in few subjects we don't have Bare Act like jurisprudence, administrative law. So except those subjects, for almost all the subject we have Bare Act, that is भारतीय न्याय संहिता, CRPC ले लो, evidence ले लो, constitution ले लो. For all these things we have Bare Act. So firstly read the Bare Act and then start your concept. So what is section 9 of CPC? Section 9 is the court shall means it has to, mandatory. The court shall, subject to the provisions herein contained, subject मतलब whatever is given in this CPC, subject to all those provision, the court shall have jurisdiction to try all suits of civil nature. So it's a like general rule is the court shall try all suits of civil nature, except suits of which their cognizance is either expressly or impliedly barred. So this is section 9 of CPC. That is, it is saying that the court shall have jurisdiction of all suits of civil nature, except those suits for which either their cognizance is expressly or impliedly barred. These two things. Now, what is this? What is this provision? Let's interpret it. Now the thing is, there is one thing that unless there is a specific provision that this kind of suit has been ousted from the jurisdiction of a particular court, unless this is mentioned in a particular provision, then we presume that the court has jurisdiction. Then the general rule is that the court has jurisdiction. So every civil suit is cognizable unless it is barred. Understood? So the general rule is every suit is cognizable unless it is barred. Then what is this suit of civil nature? Because section 9 is saying the court shall have jurisdiction to try all suits of civil nature. Now what is this civil nature? Firstly, if as a parent I say to my child that you can eat all the food of veg nature, vegetarian, that my child can have all food of vegetarian nature except those foods which are explicitly or impliedly barred. Explicitly means those foods which I have said ki no junk food, no sweets, no sugar, like this, expressly barred. And impliedly barred means if my child has allergy from that particular food, then that is impliedly barred. So the section starts with and gives us an impression that every kind of suit can be heard by the court. But then we have multiple layers of limitations also. That is, the first limitation is the court shall have jurisdiction only of the suits of civil nature. So all the criminal nature suit and other kind of suits, they are getting barred. Then the next one is the court shall have jurisdiction to try all suits of civil nature except those suits for which their cognizance is either expressly or impliedly barred. What is expressly barred? Expressly barred means that if the government, if the parliament, if a statute, if an act has been made to establish a specific tribunal or a specific court, or that act is categorically saying that the jurisdiction of civil court has not to be there, because for this purpose a special court is getting established. So this is expressly barred. So like India, we have industrial tribunal, we have election tribunal, we have tribunals related to other like industrial labor tribunals we have. Then we also have tribunal for we have revenue courts, right? So these things, these cases will not go to regular court, because for these we have express provision in special acts that their cognizance in regular civil court is expressly barred. Understood? Now this is the first one, expressly. What is impliedly barred? That is, by the general principles of law, certain things are impliedly barred. That is, if I am a court of civil nature, I am not going to address the dispute, or I am not going to address the case of criminal nature. Okay? Or maybe the remedy for which you have come to this court, I cannot provide you that remedy. So if you want a particular remedy provided by a particular court, or provided by in a particular act by a particular court, so you have to go to that forum only. Understood? So maybe consumer forums have some extra power, or they may give you some specific kind of relief. So if you want that relief, go to that court, because as a civil court I cannot give you that particular relief. So this is impliedly bar, that is, I do not have, as a court, I do not have that power to give you that relief. Understood? And also in CPC or in law, we have a maxim that where there is a right, there is a remedy. So this is again the general provision. That is, some acts only give you or only creates your rights and liabilities. Okay, that is, this is your right, this is your right. You have right to divorce your husband if these are the grounds. You have right to take part of your property, take share of your property in your ancestral property. So certain acts create right, but they don't give you any remedy. For example, Bharatiya Nyaya Sanhita says that if you are stealing something, you will be punished. Then what? Okay, I understood that I will be punished. But how I will be punished? Who will come? And who will come and how that person will take me? Then what will happen? Whether there will be a trial or not. Okay, so substantive law, that is BNS, and family law, or I can say transfer of property law. Substantive law only creates a right or limitation. Okay, but they never talk about the procedure or remedy. Now in case of CPC or in cases of civil rights, where you have an act which creates a right to you but has no remedy in it, then you can blindly come to the civil court, because that is in general, that particular act has no particular remedy, is not providing remedy, so you can come to the civil court directly. But if there is a special act and giving a special remedy, that is specific relief act. Now in specific relief act, we have multiple kinds of relief, that is restitution of the original position, and also maybe performance of the contract. So that act is talking about those relief, those particular kind of relief. So if you want those reliefs only, go to that act. Don't come to civil procedure code, civil courts. Understood? So this is impliedly bar. That is, if this court is not able to give you a particular remedy because that is not in its power, then you go to the particular court. So this is expressly and impliedly bar. And this thing, what I just told you about impliedly bar, it has been held in the case of Jitendra Nath versus Empire India and Ceylon Tea Corporation, AIR 1990. Understood? Now, we'll talk about this. Questions in dispute. So, we were understanding what is civil nature, because section 9 is saying that the court shall have jurisdiction to try all suit of civil nature. Now, what is suit of civil nature? So, a suit of civil nature is a suit in which the principal question in the dispute is related to determination of right. Determination of right. Principal question, not incidental. Principal question relates to determination of right. Understanding it? Now, this determination of right or this question shall not be related to any political, social or religious status. So, these things has to be ousted from the jurisdiction. They are not considered as suit of civil nature. So, suit of civil nature is a suit where the principal question will be a question related to determination of right and will not include any cases which relate political, social and religious questions. Understood? Now, second situation is, first situation is principal question of determination of right is civil. Okay, not these things. Second question is, that is, sometimes it happens that in order to decide the principal question, the principal right, we have to decide these matters also. We have to decide something on religious or something on caste matter. So these things comes as incidental. That is, they are not the primary questions, but they are incidental to decide the primary question. Understood? So, in these cases, these will not be considered as out of the jurisdiction. So, if these things are coming as the incidental question, then it's fine. The court's jurisdiction will not be ousted and the court has every power to proceed with this kind of dispute where the principal question is purely civil in nature, that is not related to these three things, but in order to decide it, these some questions related to political, social and religious has to be answered. Okay? So in that case, this can be addressed as an incidental question. But if it is the primary question, that is, court can never sit and decide Modi is right or Rahul is right. Court will never sit and decide are you a Brahmin or you are a Kshatriya. Okay, court will never sit and decide by what way you are supposed to do puja. Court will not decide whether you are supposed to take bath before puja or not. Court will not decide whether you are supposed to have fasting 9 days during Navratri or not. Okay, so these are religious questions. Court will not decide that whether a person of a particular caste has to follow a particular tradition or not. No, ये caste के question, politics के question, religion के question, court will not sit and decide. But only if they are incidental to the principal question, then only they will decide. Understood? And then the lastly is, there is always a presumption of jurisdiction. So generally, the general principle is, the presumption is that the court has jurisdiction. You have to either rebut it or you have to produce a statute, produce a provision which is clearly saying that this particular court has no jurisdiction here. Okay, so, and this was held in this case of Guru Bakhsh Singh versus Financial Commissioner. Understood? So what is this? A statute ousting the jurisdiction of a civil court should be strictly construed. That is, if a statute has provided that there is no jurisdiction of this particular court, then it has to be interpreted as it is. Strict construction. Okay. And let me check whether I have skipped something or not. Yes, just one more thing. Have some example of what all suits are of civil nature and what all suits are not of civil nature. So for example, suit of civil nature is suit relating to right to property. That is our civil right. है ना? Suit relating to right to worship and right to offering. See, it is related to religion. Right to worship is a civil right. That is, nobody can prohibit you to enter into a temple, barring some exceptions, not talking here about Sabrimala case or other things. ठीक है? So generally nobody has a right to prohibit your entry into any temple. But the thing is, on this thing the court will decide that your right to enter into a temple has been violated. But the court can never decide that once you have entered the temple, how will you conduct puja? How will you put tilak? So these matters of pure religion, that is pure religious ceremony or matters, will not be decided by the court. Only up to the limit where your right has been violated. ठीक है? Second one is, that is suit relating to taking out of religious procession. Now if you want to take out religious procession, in Hindi we say julus, so you can do it. That is your right. That is your right of expression, है ना? So right of belief that you can do. If somebody is prohibiting you to do so, you have every right to go to the court. But the court will not hear a matter between the two parties where one person is saying this procession was wrong because the deity you were presenting in the procession was not wearing garland. अब ये सब क्वेश्चन के लिए कोर्ट विल नॉट सिट बिकॉज दे आर प्योरली रिलीजियस मैटर. Maybe this sect of people want to garland their deity and the other sect of people are keeping their deity as what to say, without any garland or tilak or as simple as they want. Okay, so these things will not be decided by the court, only that whether you have right to take procession or not. This is the civil right. Understanding? Then suit for damages for civil wrong or breach of contract. So whole contract law procedure is here. Now suit for a specific relief, suit for restitution of conjugal right, family matters में husband wife, a suit to declare election of a candidate as contrary to law. Now this is not a political question. I am not deciding that whether Modi is doing good or not. No, I am deciding as a court that whether Modi has rightfully won the election or not. Okay, so this is the suit of civil nature. Also, what all things will not be said as suit of civil nature, that is suits involving particularly caste question. अब for example I am a Brahmin and my gotra is Kashyap gotra. ठीक है? Now some other person is coming, no, you cannot be a Kashyap gotra, you should be Bhardwaj gotra. Now we two people fighting on our gotra, we cannot go to the court. This is purely a caste question. ठीक है? ये डिसाइड नहीं करेगा कोर्ट बैठ के कि तुम किस गोत्र के हो, तुम कौन से ब्राह्मण हो. नो, रिलीजियस कास्ट क्वेश्चन विल नॉट बी एड्रेस्ड. अंडरस्टूड? देन नेक्स्ट वन इज सूट्स इन्वॉल्विंग प्योरली रिलीजियस सेरेमनीज. नौ दुर्गा कैसे करना है, दशहरे का पूजा कैसा करना है, ये सब डिसाइड नहीं करेगा कोर्ट. रिलीजियस सेरेमनीज. देन सूट फॉर रिकवरी ऑफ वॉलंटरी पेमेंट्स और ऑफरिंग. जो आप ये दान वान नहीं दे देते हो, तो तुमने कितना दान दिया, तुमने कम दान दिया, तुमने ज्यादा चंदा दिया, ये सब नहीं करेगा. दिस इज वॉलंटरी ऑफरिंग. ठीक है? सो दीज थिंग्स विल बी सेड एज suits of not civil nature. They all are political, social, that is religion and caste and religious. ठीक है? So this is all about section 9 of CPC. Thank you everyone.